to the Solo and Small Firm Summit. I've been introduced before, but I'm Cindy Elkins. I'm chair of this program. I hope everybody is enjoying it and that you will come back next year. This is an event that we've been planning for the better part of a year, and we do very much take into consideration all of your comments and suggestions. So in relation to the programs that you're attending, if you can please be sure to fill out the evaluation forms. They are looked at and they are taken into consideration for next year's programming. If you have any particular ideas and suggestions for topics, we're always open to those as well. So this year, I'm very excited to have with us today Associate Justice Carol Ann Corrigan of the California Supreme Court. As I mentioned earlier today, this is the first time that we've had a Supreme Court Justice with us at the Solo Summit. So this is something very special, and we're very excited about it. And before we before we jump into our conversation with the Justice, I want to just give you a little bit of background about her, and then she'll fill us in on some of the particulars of her rise to the Supreme Court bench. Before she graduated magna cum laude from Holy Names College in Oakland, which she presumes nobody has ever heard of before. And she graduated magna cum laude from there. Before undertaking her legal education, Justice Corrigan was pursuing a career in psychology to get her doctorate, clinical psychology at St. Louis University. Then she changed paths and decided to pursue her legal career. She received her JD from UC Hastings Law School in 1975. Following law school, she worked for 12 years as a deputy district attorney in Alameda County. Then in 1987, she was appointed to the municipal court bench in Alameda, and then in 1991, she was elevated to the Superior Court, also in Alameda County. Then just 3 short years later, Governor Pete Wilson nominated her to the California Court of Appeals, where she served for 12 years. During her time at the Court of Appeals, Justice Corrigan served on the California Judicial Council and was selected to lead the Judicial Council Task Force on Jury Instructions, which I'm sure was a daunting task, to say the least. It was Justice Corrigan's goal to turn the jury instructions into plain English so that jurors could actually understand what we were instructing them to do. This was a 10-year term, but it got done. It got done, and we are all grateful for that. As a result of her amazing efforts on the Judicial Council, she received the California Judicial Council Jurist of the Year in 2003. Then in 2005, our honored guest was nominated to the California Supreme Court by Governor Schwarzenegger. And then at that point in time, she was the fifth woman to have served on the highest court. In 2014, Chief Justice Tani Keneal-Sekui, I never can pronounce her name properly, appointed Justice Corrigan to chair the executive committee of the Commission on the Futures of California's Court System, and the purpose of that task force was to recommend to the Chief Justice several initiatives to effectively and efficiently serve California's diverse and dynamic population by enhancing access to justice, and that is something that we at CLA are continuing to explore with our Access to Justice program. In addition to her outstanding contributions to the legal profession, Justice Corrigan sits on many boards, too many to name here, but she is very civic-minded. She currently is on the board of the Holy Names University, the St. Vincent Day Home, the Goodwill Industries, and she has taught at the National Institute of Trial Advocacy for many years and teaches at, as we learned a little bit earlier, the University of Notre Dame at least once a year for a trial program. In 2016, Justice Corrigan received the Judicial Council's Excellence in Judicial Education Award, and absolutely last but not least, she has served on the President's Commission on Organized Crime and was a special consultant to the President's Task Force on Victims of Violent Crime. So please help me welcoming Associate Justice Carol Corrigan.
I really liked all that stuff you made up.
There's so much more we could have said, too. Before we jump into our questions that we've prepared, can you tell our attendees a little bit more about the nomination process and how you felt when you got that call?
Well, it's a little like getting struck by lightning, you know. It's a very strange thing. And so you know that you're being considered because people reach out to you and ask you to apply and all of that. And then it's radio silence for what seems like forever. So I kind of have a reputation for working late into the early evening anyway. And so one day I come home and there's a message on my machine that comes in at like, this is in the old days when you got a message on your machine, that came in at like 10 after 5. And it said, this is somebody from the governor's office. The governor would like to speak with you. Would you please call us back? And now it's like 8. So, and I'm thinking, why wouldn't you call me at my office where I actually am? So I rush to the phone and I dial the number and I get the governor's office and the janitor answers the phone. So, and you know, it's all kind of secret. You weren't supposed to sort of let on the secret stuff. So I'm trying to discreetly tell this gentleman that I'm returning a call and blah, blah, blah. And he goes, I don't know what to tell you, lady, there's nobody here. So I said, okay then. So the aide who called me had left his cell phone number. So I call that, and it goes right to voicemail. And so I discreetly say, Mr. So-and-so, I understand that you've been trying to reach me, and blah, 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 and I'm at home, and you can reach me at this number. Okay, so I hang up, and now what do I do? You know, I'm like walking around my kitchen talking to the cat, you know, because you're reasonably sure that if you're not getting the job, the governor doesn't call you to tell you. You know, somebody else calls you to give you that information. So now I'm pacing around, and eventually the aide calls and says, oh, thanks so much for calling us back. The governor is at a dinner, and he wanted me to call and see if he could call you later. Would that be too inconvenient? Oh, no, tell him to, you know. So I said, certainly, whatever is convenient for the governor, and he's obviously having a long evening. If you'd like to call tomorrow, if that would be better for him, of course, that would be fine. And I'm thinking, please don't do that. So, so we hang up, and now there's more pacing around the kitchen talking to the cat. And finally, the governor calls, and we have a lovely chat. He explains the process, and somebody will be calling me tomorrow morning, and stuff like that. And of course, as with most judicial appointments, you really are not authorized to tell anyone that this is happening because the governor's office wants to make the announcement, very appropriately so. And so now more talking to the cat. I mean, and there's like no one I can actually speak to. But eventually they announced it, and then it came out. And then all my friends made fun of me because they're my friends and they would do that.
What did the cat have to say?
The cat was very impressed. Next morning, the cat stood to attention. It was very
That's terrific. So you've been on the bench now for a few years.
a really long time.
A really
apparently.
long time. Tell us just a little bit about what a day in the life of a Supreme Court justice is.
It's really quiet because all we do is sit around and read and write and think deep thoughts about the law. When I first went on the Court of Appeal, I went to visit a friend of mine who was on the court, and he took me into an office and closed the door, and he said, listen, you could hear your heartbeat in here. You know, he said, you could die here and no one would know for days. Which is kind of true. There's so much churning of paper and so much exchanging of drafts and whatnot, which we can get into, that we're all just kind of hunkered down, you know, with our little lighted candle, studying drafts, studying all the great briefs that you write.
So what issues do you feel are most pressing today that are coming before the court, if you can talk about that?
Well, I mean, the fascinating thing about being on this court is that if it's a pressing issue, it's coming to us. So we always have a fair amount of SLAP. We always have a fair amount of employment law. We always have a fair amount of CEQA. And on the criminal side, obviously, there's been a lot of change in the way the state wants us to approach capital appeals. So we're sort of we and our partners on the trial court who are kind of shell-shocked now that it's become apparent that they're going to have to do some of this. We're all still trying to figure out that process because that's a little bit like, changing the course of the Queen Mary in the middle of the Atlantic. But, capital litigation is about a quarter of what we do. So it will be very interesting to see how that changes. And whether we then have more opportunities to take more civil cases, for example. I knew that would make you happy, Ben. So it's never boring.
Okay. And my apologies, I forgot to introduce my co-moderator here today, Ben Schatz. We've snuck him in because he is not a solo or a small firm attorney. He is a partner with Manat Phelps in their appellate division. And Ben and I sit on the litigation section executive committee together, and I'd gotten to know him. And I thought he would be a wonderful addition to our panel today. So my apologies for not introducing you earlier.
No, thank you for inviting me. So, Justice Corrigan, the typical lawyer doesn't interact.
Is there such a thing as a typical lawyer?
Sure, there is. The typical California lawyer does not have any interaction with the California Supreme Court, although that's most likely to happen in a petition for review. Right. So I wanted to talk a little bit about the petition for review process and how a case gets from out there to you.
Okay, so there are a number of layers, and really nobody who hasn't worked at the court or specializes in this knows any of this. Is like the secret sauce.
Share the sauce.
If you are making a petition for review, it is helpful to understand just kind of the steps we go through on the inside. So you file a petition, and it will go first to a lawyer on the central staff, of which we have 3. So we have civil, criminal, and capital. Obviously, all the capital cases come to us directly. So you're basically talking about civil and criminal. And what they will do is they will review your petition and the response, and then they will write a memo for the court. Every Wednesday we meet, usually for a morning, to discuss those petitions for review. And the only question before us at the moment is, are we going to take this case or not? And there are, on any given Wednesday, there may be 200, 250 petitions for review. They're divided into the A list and the B list. The A list is, you want to take a pretty good look at this, and we vote, each of us votes individually on whether or not we should grant. It takes 4 votes to grant. The B list is the snowball's chance in hell list. So if you're on the B list, you're kind of behind the 8 ball. But we do talk about each of the cases on the A list and vote. And then if there are 4 votes to grant, we grant. And then shortly after, usually the same day, the Chief Justice will assign that case to a chambers. And then that chambers will have the responsibility to do the initial draft on the case once you've finished with your briefing. So that's kind of the overview.
So how many in the audience have filed a petition for review?
Whoa.
Okay, see, and how many have had it granted? Okay, so
wow.
Yeah. So and over there, and so the question is, how is it that you get on the A list as opposed to the B list?
Okay, so we are looking for a relatively small number of things in deciding whether or not to take something. Is there a split among the courts of appeal, and is it a published split? Is this case published? It doesn't have to be, but that's one more factor. Was there a dissent in the case? Is it a matter of pressing importance? Was there a new initiative or a new piece of legislation that has everybody in a froth so that it makes sense for us to take it? Or conversely, should we let it, as we say, percolate in the courts of appeal and get a lot of really smart people on the judiciary giving us a lot of input on the issue before it comes to us? Sometimes when we do that, we will take 2 or 3 cases. Or as the cases come, we will grant and hold them so that we can figure that out. We look to see whether or not it's a good vehicle to take. Is there some procedural hiccup that's going to make it difficult for us to write a clean opinion? Those are the big factors that increase your likelihood of getting on the A list.
So the California Rules of Court say that you can't cite unpublished Court of Appeal opinions. But is this an instance where if you're trying to show a split of authority in a petition for review, you can cite unpublished opinions to show that there is a split?
Absolutely. And the point there is that you aren't citing them as authority for a given outcome. You're just saying, look, you guys, this is like a big deal. And people are all over the board on it. And it keeps coming up. So somebody up there should say something definitive so that we can have a little more uniformity in the law.
One of the bromides that falls into this category is that the California Supreme Court is a court of policy, not a court of error correction. So could you amplify that with respect to petitions for review?
Right. So having sat on the Court of Appeal and now on this court, one way to think about it is when you're on the Court of Appeal, where everybody, of course, has an appeal as a matter of right, your task is primarily to look backwards and to see whether there was an error that was prejudicial that needs the court to intervene. When we take a case, it's because we're looking forward. So we're not taking the case to necessarily resolve what one side at least is saying was either an error or an injustice, because that's what the courts of appeal do. So we are looking for cases that need either some clarity in the law beyond existing precedent, or sometimes we look at an opinion that maybe not as clear as we would like it to be, or that we would hope it would be, or that creates some additional uncertainty in the law. Sometimes when you're on the Court of Appeal, you can be looking at a whole body of precedent and say, this is awful, but auto equity sales says I have to follow it. And so justices on the court will say, we're doing this because auto equity says we have to, but you guys should take a look at this. So we're looking for cases that are going to allow us to look forward and articulate a rule that is clear and clean.
In addition to the petition for review, the rules also allow anyone, lawyer, non-lawyer, anyone in the universe, to send a letter to the court urging the court to grant a petition. And so a lot of times if I'm filing a petition, I search around and try to find people who will send in supportive letters. Cindy was kind enough to help me out not too long ago. But how helpful are those letters?
We are kind of hip to the fact that you do that, you know. but they actually are quite helpful in the sense that you may have a case that you and your client feel quite strongly about, and you are occasionally looking at it through a very narrow filter. And it is helpful in our deciding whether or not to take the case to have a little greater insight in terms of how it plays out more broadly in different facets of practice, or particularly, you know, is this a big deal in the trucking industry? Is this a big deal in more looking at employment issues more broadly? Or if we take this case, are we going to shut down the entire banking system? So having that kind, which we generally try not to do, having that degree of input assists you, because you want us, of course, to take your case as the launch pad for making a clear statement, but knowing that there's a lot of yeastiness out there more broadly is another factor in terms of whether or not we should take the case.
Yeah, I thought it was interesting when we said a minute ago, if it's important, it comes to you. I think it's the other way around. If you take it, then it's important.
Maybe. Every once in a while, we find ourselves saying, why did we take this case?
At that point in time, are all petitions answered once they're accepted?
You mean does the opposition file an answer?
Yes.
Not everybody files an answer, and it's kind of a cost-benefit analysis as much as anything else. If you know, for example, that there's a clear published conflict, chances are pretty good, and it's anything that's likely to recur, chances are pretty good that we're going to grant review, although I should say that we only grant review in about 2 or 3% of the cases where there's a petition for review. So knowing that is another part of the cost-benefit analysis. But if you think that review is likely to be granted, you may very much want to file an answer so that you can help either broaden the questions that we're going to answer or focus them more. You certainly may want to file an answer if your opponent has inadvertently either said something about the record that's not quite accurate, or has left out important things that might bear on the question of whether or not we should grant. But when you're trying to decide whether or not to file a reply and spend your client's money, you do want to be focused on what we're asking ourselves. We don't need you to tell us about the law of the sea going back to the Magna Carta, because we're just trying to decide whether or not to take the case. So if you're going to spend the money to file a reply, first of all, figure out whether or not you actually want us to take the case. Sometimes both sides want us to take the case.
There's still only 2 to 3% chance of a grant.
Exactly. But if you don't want us to take the case, this would be a good time to tell us that there's a problem with the record that's not very clean, or that there really isn't a big split among the circuits. Maybe one of the cases that, or the districts, I should say, one of the cases that was cited as a big published conflict was decided in 1934, and nobody's cited it since, and it's really, everybody's doing fine, thank you very much. Or whatever. So, if you're clear on what you're trying to accomplish in your reply, you make our job easier, always an end devoutly to be hoped for, and you can be a little more parsimonious with the money you're spending.
Yeah, I think it's hard for many lawyers to make the decision not to answer a petition, because if the other side throws something at you, you instinctively want to throw something back. But when you say that the odds of review being granted are so low, there's no shame in not filing an answer, and the court doesn't construe that as meaning anything.
Correct.
How often does the court take the opportunity to reframe what's before it?
It's not a particularly common thing, although we do it. And sometimes we do it if we either want to broaden or narrow the focus. You may have one lens that you're looking at a case through, at your particular case, and we may have 2 or 3 other cases that are kind of in the mix that perhaps we could use to ask the question more broadly. So sometimes we'll rephrase it for that reason. Sometimes we'll rephrase it because no one in this room would do this, of course, but the lawyer hasn't really drafted the question. And sometimes you get these and they say, you should write an opinion that says, we win. Well, okay, that'll be.
That doesn't work?
Yeah, no, that doesn't really help. So we will do that. If review is granted and the question has been rewritten, really pay close attention to that, because that now becomes the lens through which we are looking at the case. If you think we've made a huge mistake in the way we rephrased the question, you can certainly explain that in your briefing, but at least we've given you a little tiny sliver of a window to look through to see that we're looking at it slightly differently than the petitioner did.
So that's a little bit of a tip
Yeah.
in terms of how to proceed.
Yeah.
Okay.
So the court has 60 days to rule on petitions, but sometimes the court grants itself an extension of another 30 days.
Because we're the court, we get to.
Of course, absolutely. My question is, should we be reading anything into that?
So I'll give you a real lawyer's answer. Sometimes yes, and sometimes no. Sometimes it's very straightforward. The 3 people on the central staff are on vacation, and somebody's mother died, and so they're understaffed, and we just haven't kind of gotten to it because there is a huge press of business at any given moment. And so there are lots of people sitting in those quiet little offices churning out memoranda. But so sometimes it's just we just didn't have enough time. Sometimes it may be that that the court itself wants to take a closer look at either the issue or the way it's phrased or whatever, just to see whether or not it seems to be as pressing as the advocates who are petitioning for review represent it to be. But what you can be confident of is if we extend the time for ourselves, you're really getting us to take a close look at it. So that, but there's no magic message.
Can I just, your scarf is giving us some feedback, so sorry about that.
Yeah, clients always say, what does it mean that the court's given itself more time? And I say, it's better than a stick in the eye.
Right, yeah.
It's,
So what makes for good briefing when you get to that point?
Focus, focus, focus. It's kind of like, how do you get to Carnegie Hall? Practice, practice, practice. Remember that we are only looking at the issue you've asked us to look at or the issue we've said we'd look at. So, you know, you all know that your primary goal as lawyers is to make our job as easy as possible, right? And so the more you can be focused on the issue at hand, and I recognize that sometimes, A, that's hard just as a matter of practice and drafting, and B, it's hard when you are having to explain to your client why you haven't spent 15 pages on what a jerk the other side is. But, you know, focus, focus, focus. Remember that we've taken the case with the goal of making a forward-looking statement about the law. So we've taken the case because we think we can make a statement that clarifies some aspect of the law. So if you know that that's why we took it, and if you know that that's what we're hoping to accomplish, then write your brief with that in mind. Tell us what the rule ought to be. And the rule, don't tell us we should win, particularly if it happens on a Tuesday, because that's not why we took the case. We took the case to make a statement about the law going forward. So you should be as clear as possible as you can be about what that rule should look like, and then defend that rule. Don't use capital letters or boldface. That's like yelling at us. You know, keep the ad hominem stuff out of it. Try to keep the outrage to a minimum, because we are going to be looking at it through a fairly legally directed prism. So if you know what we're thinking when we take the case, and if you know what we're hoping to accomplish in writing on it, then that should be something of a guide to your briefing.
Well, and you sat on the Court of Appeal for many years. How is a briefing in the Court of Appeal different than briefing before the Supreme Court?
Well, often, obviously, since you have an appeal as a matter of right, you can bring up as many issues on the Court of Appeal as you want to. My recommendation generally is that you should be discriminating there as well. No one wants to see a brief that raises like 15 issues. And if you have 15 issues, 2 or 3 of those are going to be more pressing, more likely to succeed, et cetera. But there's much more breadth of briefing. And it's almost always focused on that backward-looking, the trial court admitted this evidence, or blah, blah, blah. And there may not be as much emphasis on that forward-looking, you should say something different. Obviously, justices on the Court of Appeal, when they get a case like that, know that for the most part they're writing for us, because if it's going to be a big departure in the law, probably we're going to take it to decide whether or not to endorse it. But if you can keep that in mind, the difference between looking backwards and looking forwards, that will kind of encapsulate the difference between the 2 levels of review.
So we talked about amicus briefs at the petition phase. Now that we're talking about the merits phase, are amicus briefs welcome and important?
I think they are for much the same reason, but more broadly now we really are now having the rubber meet the road. So we really are trying to articulate the rule. And sometimes the case that any individual litigant will bring will be one narrow aspect of the rule, and it's actually quite easy to run into the law of unintended consequences. You can come up with a rule that makes terrific sense in this little narrow focus, but obviously you're making a broad statement about employment law or family law or whatever it is, and you can inadvertently write a rule that sweeps more broadly perhaps than you intended, particularly if it's in an area, you know, we don't all know a whole lot about the trucking industry or, whatever. So the insight of amici who can say, and for heaven's sakes, don't say this because, we'll have to shut down banking in America, that's good to know. And often amici are in a better or a different position to make a statement about that than the individual litigant will be.
So how is it that a case ends up in your chambers with you as the author as opposed to one of the other justices?
Well, as I said, the Chief Justice will make an assignment usually the day we vote to grant, if not that day, the day after. It's a little bit of a black box in the sense that the Chief just decides. Very seldom does anybody say, I really want that one. That's kind of considered bad form. But I think the primary thing that the Chief takes into account is what everybody's workload is like. If your stock of fully briefed cases is kind of low, you're going to be up as opposed to somebody who may have more cases waiting in the wings.
So the next step is then oral argument. So how do you?
No, the next step is all the working.
Okay, what's the next step? Yes.
Okay, so,
for us, after.
Well, once you get reviewed, then of course you have to brief
we do the
briefing.
briefing.
Yeah. And it's very important when you do the briefing to make sure that you tell us both the things that help you and the things that hurt you, because you put yourself in a bad rhetorical position if you give the impression that you're trying to kind of shade the facts. But we get all the briefing, and then we really go to work on it when we get all the briefing. And so in my chambers, everybody works a little bit differently. Every chambers is a little different, but I will read all the briefing, and then I will assign it to a research attorney who then will dive deeply into the record and often will say, you need to read these parts of the record. If it's a 6-month trial, I probably am not reading every page of every day of testimony. And then they will usually consult with me, and we'll get a general sense of where we think we're going. They'll produce an initial draft. Then the author will look, before they circulate it to anybody else. In my chambers, we usually go through about 10 or 12 drafts to get it as polished up as we can before we send it out of the nest. And then it goes to everybody else's chambers. And then they go through that same process. And at the end of all that, once there's this draft that's been circulated, each chambers will reply in writing, which is actually quite different from the much less formal way they do it on the Court of Appeal. But because there are 7 of us, and because there are so many cases in process at any given time, if we didn't put it all in writing, we'd never be able to keep it all straight. So you get a formal response from each of your colleagues who will tell you, I agree, I disagree, and by the way, what were you thinking? Or I'm tentatively in favor, but I have these comments. I think you could approach this question differently, or it might be helpful if you cited this case, or you had a little more discussion about this, or whatever. Or I think I can be with you, but I have some reservations, and here are my reservations. So all of that gets circulated to everybody. And once there's an indication that there will be at least 4 votes, the author and 3 others, in general agreement with the proposed draft, then we set it for oral argument. And once it's set for oral argument, generally the authoring justice will write yet another memo that says, okay, here's what all of you have said. You liked this, terrific, thanks a lot. You hated this, here's how I will accommodate that. You have some reservation about this, maybe we ought to ask the lawyers about this. Occasionally we ask for further briefing, usually not very often, but we do. So that memo goes out, now we're all ready for oral argument.
So the decision
all
is written.
that stuff happens before oral argument.
Yeah, and that usually takes what, about 2 years, or?
In part, it depends on how long you all take for your briefing, but it can take 1.5 years to 2 years by the time you get through all that.
And we were talking earlier in terms of how you staff your court, and you've got several clerks working for you. During the process of a case taking 2 years to get through, you've got a changeover of your research clerks. How does that impact the writing?
Well, so it used to be traditional for a number of decades at the Supreme Court that the court had permanent clerks, so professional clerks. And some of our more recent colleagues who have come through the federal system and are very comfortable with the annual or every other year clerking system, like having a lot of fresh young faces who are working on the staff. And there's kind of a split, actually, among us. So some of us have 5 lawyers who are permanent, assigned to us. They've been working with us for a long time, and they're going to be around next year. Then there are other chambers that have somewhere between usually 2 and 4 annuals. If one of your colleagues has somebody who's an annual, obviously there's a big push to get that case on for argument before the annual goes away, because once they go away, then somebody has to, take it over from scratch. So it's one more level of potential complication.
I would think it would just muddy up the waters just a little bit.
It can, although like any other option in a system, there are advantages and disadvantages to both. But for those chambers that use annuals, that's another factor to be managed.
So from the show of hands, you could see that there were very few people here in the audience that have argued before or submitted a petition. What advice can you give to the solo or small firm attorney that says, we can do this, we don't have to be particularly from a Manette Phelps, no disrespect, but the people that you don't have to be a big firm attorney to take on something like this?
You can definitely do this. I mean, we're not trying to fix the Hubble telescope, and we're all really smart people, so you can do this. It can be a little daunting if you don't know how to dot all the I's and cross all the T's, or know all of the ins and outs of the rules of procedure. But our clerk staff is pretty responsive to answering questions if you just need to know what the time limit is, or what color the backing ought to be if you're in Los Angeles, or questions like that. It can be helpful to to seek the assistance of somebody who does it all the time, just like in any walk of life, but there's no real magic to it. The trick, I think, is for somebody whose primary practice has been in the trial court being an advocate, particularly a jury trial advocate, but even a court trial advocate, to remember that it's a very different enterprise, that the questions are much narrower, and we are generally looking at it in a fairly clinical way, as opposed to the kind of presentation, I say as an old trial lawyer, that you would make in the trial court, when you really do have to be far more, or at least mindful of the ethos of your case.
And Cindy, I would say, when you're at the lectern, you're a solo practitioner.
That's right.
Doesn't matter what firm you are. There's one lawyer up there, and seven justices, and one lawyer on the other side, and that's it. And with respect to oral arguments, for the past few years, they've been webcast, and they're archived so that anybody can watch them live or watch them later. There's been a tremendous resistance at the US Supreme Court to video oral arguments, and the argument has always been, well, that will change how arguments affect. So, your court's been televising arguments. Has it changed anything?
No, it certainly hasn't appeared to change anything from our perspective. We do what we do. We're going to say what we say. In my case, it's always a little scary that somebody's recording it and broadcasting it, but that goes with the territory. I see no difference in the way lawyers conduct themselves or any of that. So I think some of it is a generational thing. Change is hard, and the more senior you become, sometimes the more difficult change can be. But we often will have lawyers who will say from the podium, when the chief says, all right, if you want to reserve 3 minutes for rebuttal, you're done. And the lawyer will look up and sometimes say out loud, really? It seems like I just cleared my throat and organized my papers, and now you're telling me I'm finished? So there really isn't that much time to do anything hair-raising just because you're being recorded.
Mind your P's and Q's a little bit more.
Indeed.
Yeah. In terms of the oral argument, did the justices collaborate on who's going to ask what questions, or is each justice pretty independent?
Oh, we're very independent. And, you know, often, because we've all thought about the case a lot before oral argument happens, you not only know what your take on the proposed draft is, but you kind of know what everybody else's take is as well. We don't get together and say, okay, you ask them about this and you ask them about that. Sometimes, just like on the real Supreme Court, the U.S. Supreme Court, some of the questions will be asked of the lawyer, but directed to something that you know one of your colleagues may be concerned about or may see differently. So in that regard, sometimes you're standing at the podium and you kind of feel as though you're just the foil. But everybody brings their own take to it, and everybody pretty much takes their own responsibility for getting to. Sometimes we have to elbow one another out of the way. You know, we all can't wait to ask a question.
Say, no, I was going to ask that.
Yeah. Oh, that doesn't deter us. We just ask it again.
Okay. And then, how is it assigned within the court? Who's going to write the formal opinion? Does that go back to whoever the case was assigned to originally?
Right. And when it's assigned, it is assumed that that justice is going to write the opinion. And the only time that changes is if the draft is circulated and everybody, you can't get 3 other votes. Then you have a decision to make whether or not you are going to take everybody's input and write it the other way, which is not at all uncommon, or whether you're going to say, no, I don't know what's wrong with you for, but I'm not writing it that way, in which case the justice will say, I'm going to give it up, and the chief will reassign it to somebody who's taken a different position. But once it's going to oral argument, it's pretty much going to stick with the justice who wrote the calendar draft unless something really hair-raising happens.
And then what would prompt a justice to write a formal dissent?
Well, if you really, really disagree. We actually, and this has received some commentary in the, among the academicians, we actually work pretty hard to find a middle ground. The clearest opinions are the 7-0 opinions, because then you have a pretty good idea that we've said it, and it's pretty much settled law, and we pretty much see this the same way. When you have lots of different judges saying lots of different things, I think it can make it very difficult for trial judges and appellate judges and practitioners to know exactly what you're saying. So unless you feel fairly strongly about something, or unless you think that you are writing for 10 years down the road, you're writing for a new court, dissents are relatively uncommon. Concurrences and dissents, or straight concurrences but taking a different tack, are sometimes more common. So a judge may decide to write separately to say, I agree with the outcome here, but I wouldn't rely on so-and-so versus Doe because for these reasons, and I think it's better to analyze it this way, or so you're making a different comment. Sometimes you are speaking to a very different audience. Sometimes you write separately to speak to the legislature, for example, or to speak to the electorate, for that matter. But if the goal is to have as much clarity in the law as possible, the more we can find a middle ground to speak with one voice, our general view is that's a good thing. And sometimes you will see us very intentionally saying, we're just deciding this. We're not deciding this. So if you want to talk about this, come back. But we're not making a pronouncement on this. It's broader aspect. And there is, there are tea leaves to be read there in terms of how those cases are going to get teed up in the trial courts. But it's usually an indication, I shouldn't say usually, but it can be an indication when you see the court say, we are intentionally not deciding X, that there may be some difference of opinion among the 7 of us about how that thing we're not deciding today might come out. So if we say something like that in your field, you may want to find the perfect case to create the perfect record that allows us to move in that direction.
In a case that, I know we're not going to talk about specific cases, but a case that was fairly substantial last year, the question was left open as to whether it was prospective or retrospective. And then a petition came up to the court for review as to make a pronouncement on that, which was not accepted. How does that process work in terms of the prospective or retrospective application of a decision?
Okay, so there are rules that regulate that, and usually, and there are two aspects of it. If it is a question of whether or not a newly adopted statute applies retrospectively or prospectively, we look to see what the legislature said about that, whether or not they've made a statement of intent to have it apply retroactively, whether or not it is a substantial change in the law that creates greater lenity for particularly a criminal defendant. All those things augur in favor of making it retrospective. The general default rule is changes in the law are prospective only. Again, in the criminal area, if we draw a conclusion that the Constitution really compels something, and there hasn't been a change in the Constitution, we just discovered that it says this, then often those cases will be applied retroactively because, again, the rule of lenity may be brought into play. If we say we're not deciding whether it's going to be prospective or not, it is usually because this case is not a good vehicle to decide that issue. And sometimes if the next case comes up and we don't grant review, sometimes we're waiting for the courts of appeal to grapple with that a little bit more. Because the courts of appeal are a huge aid to us in the sense that they're all really smart people too. And they have, there are a lot more of them, so they have a greater breadth of experience than 7 people can have. And so the opportunity to let 2 or 3 panels or 2 or 3 districts speak to an issue can be very helpful. So it usually means either that we didn't think this was a great vehicle, or we're just waiting to see what people say.
When Cindy shared with us your background, she made clear that you practiced as a trial lawyer, you were a Superior Court judge, you were a Court of Appeal justice, and now you're a Supreme Court justice. But you have a number of...
I keep getting thrown out of jobs, apparently.
Well, you have a number of fellow justices now who did not follow that path at all. In fact, many had never worn a robe before. And how has that changed the court, and what does that mean?
Well, it's been wonderful in many regards because because we are a court of policy and not just a court of error correction, the more breadth of analytical bandwidth you have, the more interesting the discussions. Not to suggest that the discussions weren't interesting before, but it brings a different flavor to the discussions. And often those judges, particularly the ones who came out of academia, have younger annual clerks. So we're getting different kinds of eyes on the questions than was the case under the former system. So there's a lot more diversity of experience and insight and background. So, and it's nice because there are 3 of us who kind of came through that route, who were practitioners before and then kind of sat in the various chairs. And now we have these colleagues who have a wonderful different kind of experience. So I think we're very lucky.
We do have some time for some questions, if anybody has anything for the justice.
As long as they're not too hard.
And we can't talk about any particular case that's pending. Yes, sir.
I'm curious, with the change in the rule that you can now cite a court of appeal opinion that's been petitioned for review granted, is the court exercising more depublication notices or to deal with that?
Well, what happens now, we did change the rule so that we don't automatically depublish a Court of Appeal case just because we took the case up, which used to be the rule. Now we kind of look at those individually to see whether or not and there really isn't a message that goes there. Just because we didn't declare one case depublished doesn't necessarily mean that the case we granted on is going to come out a certain way. But we leave that on the books to provide guidance so the trial courts aren't operating in a vacuum. And then we will take a number of cases that we call grant and holds. So we've taken a case to decide this issue, and we may get another 20 petitions in cases that present a similar issue. And then once we've decided this one, then we will go back and decide that this case needs to go back to the Court of Appeal, or this case needs to go back to the trial court for further discussion in light of this case. Or we can just dispose of those if it works, whatever we decided here, to just dismiss those appeals.
A few decades ago, it seemed like the court was using depublication as a way of shaping the law, and now that seems to not be the use, and the numbers have dropped significantly. Is that right?
And that's by design. I hesitate to speak about a court that I had nothing to do with, but the perception was that the court, if there was something from the Court of Appeal and the Supreme Court just didn't like the outcome, they'd just depublish it. I can remember lawyers saying, oh yeah, the First District in San Francisco just decided this case, you better cite it real quick because it's going to be depublished next week. We really try very hard not to do that. And there was a concerted decision made by previous members of previous courts that if the Court of Appeal made a mistake, and we think the Court of Appeal made a mistake and it has taken the law in a bad direction, we should say something about that. We shouldn't just have kind of a pocket veto. So the number of depublished cases has gone down appreciably. Every once in a while, there will be a case that is an outlier, or there will be a case where the law is quite clear in its overall development, but this just, whoever wrote this took a left turn at Jupiter, and we'll depublish that because we really don't have anything else to say about that. There are 15 other cases that got it right, and we will depublish a case so that it doesn't upset settled law, but it is much less common now.
There was a question over here.
We've got a mic coming to you, so right over there.
Forgive me for asking this question because I wouldn't dare ask a question during oral argument, and I have no justices that are neighbors. But what is your personal life like, and how was it affected becoming a Supreme Court justice? Can you only have your cat as a friend? Are you afraid? Are you afraid of being kidnapped?
I've been doing it for so long, I guess it seems odd to me to think that, I wasn't exactly born doing this, but I have been doing it for a long time. We're just regular people. I'm sorry we aren't neighbors. I'm a pretty good neighbor too. But it's like all of your jobs. You're real busy professional people. But we are also mindful that because of what we happen to do for a living, there are rooms full of people who want to ask us those kinds of questions. So we are mindful of our additional role in the system. Lots of us are teachers at law schools and other places. Several of my colleagues are quite active in academic writing. But then on the weekends, we sit at home and do the New York Times crossword puzzle too. So
There's a couple of questions over here.
While we're moving the mic, it was mentioned that you were on the committee for the future of the courts, so or the justice system as a whole. So what should we be looking forward to for future changes?
It's going to be much better. Yeah. It was actually quite an interesting undertaking in the sense that Governor Brown and the chief both wanted to bring together a group of people who really would look over the horizon. You know, as judges and lawyers, we're very comfortable doing what we do and doing what we've been doing for a very long time. And we were really challenged to look at a tabula rasa, and if we were going to make changes, what kind of changes should we make, and how, you know, how will technology affect it? How does California's broadening population affect it? What do we do about the fact that there are 75 or 78 different languages spoken in California? What do we do about interpreters? What do we do about court reporters? So it was a very interesting undertaking. And we published a big report. We made a lot of recommendations, and some of those are moving their way through the legislature. We recommended often that if there was going to be a change, and I am going to let you talk, if there was going to be a change, that we might consider having a pilot program in 1 or 2 counties, because we've stubbed our toe on that in the past, haven't we, in the course of all of our practice of law, where somebody has a great idea and they change everything for 58 counties, and then oops, we find out that it doesn't really work all that well. So if you are interested in an area, it would be a good idea to find out if in the county where you practice there is a groundswell of support for having a pilot program.
So a significant difference between the federal judiciary and the California judiciary is elections.
Mm-hmm.
Can you talk about the experience of going through a judicial election, and do you think it's a good idea to have judicial elections?
I have to say that blessedly I have never been opposed in an election for reasons that are not completely clear, but very happy. So I can't really tell you from personal experience what the election process looks and feels like. But obviously it's got all the challenges that you can imagine. And I know you are all aware that if you were on the trial court, you can there can either be a petition to recall you, or you can be run against. On the courts of appeal and on our court, nobody can run against you. Although people can get very cranky about it, and they can ask every 12 years, they can ask not to reaffirm your election. But you know, I think it is strictly a policy call that if you have judges appointed for life, there are good things and bad things about that. It can, once they get the job, which can be very political at the beginning, but once they get the job, in theory, they are not buffeted about by the vagaries of the political process, and whether or not that actually turns out to be true, in part depends on the judicial philosophy of the judge. Some judges are much more open to using their position as a bully pulpit or taking the law in a direction that they think it should go in, and other judges are more dedicated to a more restrained approach. But at least they aren't, in theory, putting their finger to the wind and seeing how people want to come out. In California, historically, the thought is that we don't just get these jobs because we're real smart or cute or whatever. We get these jobs and hold them in trust for the people, so that who actually let us have the jobs. And so there is a value to giving the people who we serve and in whose name we act some measure of input periodically to make sure that people don't just completely run amok. And the notion that on the trial court you're up every 6 years, or on the courts of review you're up every 12 years, is an attempt to kind of set that balance. And like many things, in my view anyway, there is no one right way to do it. There are advantages to both sides. The one thing I will say is that there are many states where the whole election process is very, very political, and where the terms turn over much more frequently. And in talking to judges from those states, that can be corrosive of the system, because judges are constantly in the process of trying to raise money. Judges are perhaps much more mindful of the next election cycle. And so what that does is give the people much more input, which is not necessarily a bad thing, but it comes with all those other downside consequences. So it's a policy choice for the people.
Do we have time for one
There
more
was
question?
there was one other question.
Yeah.
a hand I saw over here somewhere.
You know, as the microphone's being passed, I think I read recently in Texas, where they have contested elections, there was an intermediate appellate court justice who said that he was going to run for the Supreme Court and promptly lost his job because apparently if you announce candidacy, you can't hold your office. And so he fired himself accidentally.
Yeah, giving new meaning to shooting yourself in the foot. That's it really is a good idea if you're going to make one of those pronunciamentos to know what the rules are before you make one.
We have a question over here.
Hi, good afternoon. In the last 10 years or so, particularly at the federal level, there's been a real push towards blessing compelled arbitration agreements, particularly in recent years in the employment context and the consumer context. You mentioned earlier that employment matters continue to take up a large amount of the court's time. Have you noticed in your tenure any effect of those arbitration agreements on the ability of the court to weigh in on important topics? Particularly, you know, we being small and solo practitioners, I think a lot of us have clients that are individuals or very small entities who have a lot less bargaining power in things like that. I'm curious whether that has had a chance to percolate up to the Supreme Court and affected or caused any worry about the Supreme Court's ability to weigh in on important issues like that.
That's a very sophisticated question, and it is something that is often talked about, somewhat anecdotally. And when I say talked about, I don't mean that we just sit around and talk about it among ourselves, but that it is broadly talked about in the profession. And it certainly can result in discrete kinds of issues eluding review. That's a potential. But frankly, I haven't actually seen that. Maybe you are much closer to that than I am, but it is something that we all have to be mindful of, but I haven't necessarily seen huge carve-outs of questions that are just never getting to the courts of review because of the arbitration agreements.
And we had one other question, I believe, on that side of the room.
Good afternoon. You talked about the 7 justices, the hard work you all go through before oral argument and all the exchange of information and briefing and letters and notes. By the time you get to oral argument, how much difference does it really make for an attorney to orally argue his case?
Well, okay, so that's also a good question. The truth is, there is a draft opinion, and we have thought about it a lot. But I will tell you, on my very first oral argument many years ago on the court, 2 cases were completely flipped after oral argument. And I remember thinking, whoa, this is going to be really cool. And there haven't been that many since. But it is not to say that they don't sometimes go the other way after oral argument. But if you've done a good job in the briefing, and frankly, if we've done a good job in all of that working that we talked about, you would hope that we wouldn't just wake up one morning and go, wow, you know, I guess
Never
we
thought
do.
of that.
Yeah. So what happens as a result of oral argument is not necessarily that the case is going to completely go the other way, although that does happen, but not very frequently. What is more likely to happen at oral argument is that you can have some input on our thinking about exactly how the rules should be drafted, or how broadly the opinion should be written, or whether or not we're going to stumble over that unintended consequence that, you know, we need to be mindful of in shaping the rule. But I will say again, if you come for oral argument, be prepared for one of us to say, so counsel, what is the rule that we should write? Be prepared to tell us the answer to that question, and even better, tell us that in your briefing. And please don't have it be like a 14-part test that, that happens one way in May and another way in December.